Hi, Jim. You're muted.
There we go.
Hi, how are you?
I'm good. Yourself?
I'm good too. Sorry, I'm a little bit late to the meeting. Of course, my Zoom decided to update, but we have a good number of participants on this call right now. We'll maybe wait just a minute or two more to see if anybody
Yep,
wants
it's
to join.
fine. I've got all the rest of the afternoon, so we're good.
Awesome.
And I did get all of the questions, so.
Okay, perfect.
And
Hi,
I'll
Madhura.
I'll record it on this end,
Okay.
and then provide you with a copy of it.
Okay, perfect. That would be awesome.
Good.
Yes, somebody had a question. I heard somebody else speak up.
Yes, that precisely was the question what Mr. Arkell just, I
Okay.
forgot his name. So he just replied. Yeah, I was
Okay.
thinking we can get an access to this recorded video at a later point of time.
Yes, you will. Okay, awesome. I think we can go ahead and begin. So I would like to welcome Jim Arkell.
I'll start the recording here.
Yes, that sounds good.
Recording in progress.
So he has already given about 3 presentations previously to OSU Postdoc Association, and it's been so well received. We always have a good number of participants joining in, plus asking questions. So he's going to be doing his presentation, and then after that, there was a series of questions that was already collected up until Tuesday. So he's going to go ahead and answer those, and then we'll open the floor up for any additional questions. So without further wasting any time, I'm going to ask you to go ahead and start your presentation, Jim. Thank you.
Thank you. My name is Jim Arkell. I'm with the Dunn Law Firm, and I am an immigration attorney, and I'm thrilled to be here this afternoon to share some information with you about what your options are as an international student postdoc researcher with respect to staying in the U.S. on non-immigrant visas or eventually moving onto a green card and getting your permanent residency. I've been a lawyer for over 30 years. I spent the first several years of my career as a trial lawyer. I spent many years as a law professor, and I've been exclusively practicing immigration law now for several years. And I was an F1 student. I was on a green card for over 15 years and subsequently got my US citizenship. So I'm very familiar with the process. I've been through it myself. I work with my brother, Tom Arkell, who's been an immigration lawyer for over 20 years. He too was a F1 student, went through the same process, got his green card and his citizenship. We represent several major universities in the Midwest related to their immigration matters. And I've filed literally hundreds of cases every year on behalf of postdocs, PhD students, and researchers with respect to both non-immigrant and immigrant petitions. So today, I'd like to go over, like I said, the non-immigrant options you have, and then move into permanent residence. So as an F1 student, if you came to the US like I did on an F1, when you finish your degree, you are entitled to optional practical training. You can get optional practical training at each educational level. So you can get a year of OPT at the end of a bachelor's, year of OPT at the end of your master's, and a year of OPT at the end of your doctorate. If you are in a STEM program, you can get a STEM extension at 2 of those levels. So the STEM extension is an additional 24 months or 2 years of optional practical training. So theoretically, you could have a total of 7 years of OPT if you were in a STEM program. To be able to avail yourself of the additional 24 months available to you, first, you need to verify that you are, in fact, in a STEM program. And the other thing is the employer must be E-verified. If the employer is not E-verified, then you'll have to find a new employer to get the STEM extension, because without that E-verification, they cannot extend your STEM. So make sure that your employer is E-verified. I have had people contact me in a panic because they'd found out at the last minute that they could not get their STEM extension because the employer was not E-verified. And there are a few major research universities in the US that are not E-verified, and a lot of people make that assumption that because they're a major research institute that they are E-verified. So don't make those assumptions. Don't assume that your STEM program qualifies, or excuse me, that your program qualifies as a STEM program. Again, I've had people contact me because they made the assumption that their program was STEM, only to find out that it didn't qualify. So make sure your program does qualify for the STEM extension, and if so, make sure your employer is E-verified to get your additional 24 months. If you're not on an F1 through and have OPT, there's a good chance that if you're a postdoc in the United States, that you have a J1 visa. So the J1 visa is very common for postdocs and researchers because it's fairly simple to obtain. Additionally, as with the H-1B, as we'll talk about in a minute, there is no prevailing wage required. So the J1 visa was initially designed as a cultural exchange program, and it is controlled by the Department of State and not by USCIS. And so because it was designed as a cultural exchange program, the intent is that individuals who come on a J1 will return to their home country to share the knowledge and experience that they gained from living, working, doing research in the United States. Because of that intent, quite often there is what they call the 2-year home residency requirement. That is 212E is the condition that is often applied to a J1 visa. So the 2-year home residency requirement is given on the J1 under 3 circumstances. If you are on the skills list, the Department of State has a list and it's itemized by country. So the first thing you would do is look at that list and see if your country's on that list. If your country is not on that list, then the skills list does not apply to you. If you find your country, then you need to look at the list of professions listed under your country. If the profession that you were issued your J1 for is on that list, then you're going to be subject to the 2-year home residence requirement based on the skills list. The other reason you could be subject to the 2-year home residence requirement as a postdoc researcher is government funding. If you are getting direct government funding from your home country or from the United States, then you will likely be subject to the 2-year home residency requirement. Where people often get confused, including people who are issuing J1 visas and DS 2019s, is whether or not funding qualifies as direct government funding. For example, you're a postdoc researcher and your PI is getting funding from, say, NIH. Although NIH funding is supporting your research, it is not coming directly to you. So that does not count as being direct government funding. Working for a state university and being provided a stipend is not direct government funding. So the other reason is medical training. If you get a J1 visa for residency program, a medical residency, you're going to be subject to the 2-year home residency requirement. Oftentimes, when you get a J1 visa stamp, it may say that you are not subject to the 212E. However, you'll get a subsequent DS 2019. On there, there's a series of boxes, and they may check that you are subject to 212E, and then there's 3 boxes underneath. They're supposed to check why you're subject to 212E. If there's an inconsistency as to whether or not the 2-year rule applies, you can get an advisory opinion from the Department of State. You would provide them with a copy of your J1 visa, a copy of your DS 2019s, and request an advisory opinion as to whether the rule actually applies to you or not. And oftentimes you'll have one that may say government funding, when in fact you're not subject to the government funding. We filed many advisory opinions arguing that government funding did not apply, providing the evidence, providing where the money to support the J1 research came from. And the advisory opinion would come back that the individual was not subject to the 2-year rule. So the advisory opinion is pretty straightforward. You can apply for it online, fill out the forms, and then you send in the hard copy to the Department of State. And it typically takes less than 30 days to get that figured out. If you are subject to the J1 2-year home residency requirement, you can get a waiver in certain instances. If you're subject to the 2-year rule because of the skills list, getting a waiver based on a no objection statement from your home country is fairly straightforward. There are some countries where it's a little more difficult and involved to get that waiver. And then there's some countries that simply won't do it. But the vast majority of countries, getting a J1 waiver based on the skills list is fairly straightforward. If it's subject to government funding, it is more difficult to get a waiver. It becomes much more complicated. And medical training is almost impossible to get a 2-year waiver unless you can establish undue hardship that is caused to you by having to return back to your home country for 2 years. So if you're not on a J1, not on an F1, then you're likely on an H1B visa. The H1B is sort of the ideal visa to be on as a non-immigrant. The reason is it allows for dual intent. And what dual intent means is that you have both non-immigrant and immigrant intent. By being allowed to have immigrant intent, it makes transitioning to permanent residency less restrictive. In particular, it allows you to travel throughout the process without any concern. The H-1B is good for a maximum of 6 years. If you have an approved I-140, you can extend that H-1B beyond 6 years. It requires that you be in a professional or specialty occupation having a bachelor's degree or equivalent. It is employer-specific, location-specific, and job-specific. The reason it is location and job-specific is because of the prevailing wage. The prevailing wage requires the employer to pay 100% of the prevailing wage or the actual wage. So the prevailing wage is set by the Department of Labor as the wage that has to be paid for that position in that location. And so they make a determination as to what your job is, what the work is you're doing, where you're doing it, and what should be paid. So the employer has to pay the prevailing wage at a minimum. Should the actual wage be higher than the prevailing wage, in other words, someone who's working with you has the same qualifications, doing the same job, is being paid more than you are, by law, the employer is required to pay you the higher wage, which would be the actual wage. So the H-1B cap, if you are working at an institution of higher education or a nonprofit research entity or some entity associated with an institution of higher education, the H-1B is not subject to the annual cap. This means that an H-1B can be applied for at any time during the year, and it is not subject to the lottery. If you are wanting to get an H-1B in industry as opposed to academia, you have to go through a lottery. The employer registers for the H-1B lottery. And then if you are picked, there are a total of 65,000 for people with a bachelor's degree or better. And if you have a master's degree or higher from a U.S. institution, your odds go up a little bit because there's an additional 20,000 H-1Bs allocated for people with a master's degree or higher. But again, it must be from a U.S. institution. The chances of getting picked in the H-1B lottery are very low. This year, I believe there were over 700,000 applications filed for the industry H-1Bs for the 85,000 that were available. So the next H-1B registration window will be in March. And then if you're selected, your visa becomes available October 1st. So people that were selected in last year's lottery, their visa becomes available in a couple of days, October 1st. If you are on OPT and you are selected in the lottery and there's a gap between when your OPT expires and when the H-1B will begin on October 1st. For example, let's say you were selected in the lottery, your OPT expires on July 1st. You can continue to work during that gap. That's the H-1B cap gap. Only available to you if you're on OPT or the OPT STEM extension. If you have an industry H-1B and you want to change employers, or you get a promotion and your job changes, or you're transferred and located to a new city, amendments to the H-1B are not subject to the cap. So once you have that industry H-1B, you can use it, hold on to it, change jobs, do different things. And so having the H-1B is very valuable as a non-immigrant, especially if you want to move into permanent residence. So other non-immigrant visas that some of you may be on or may be available to you is the TN visa. This is under the North American Free Trade Agreement. I'm often surprised at how many Canadians and Mexicans are not familiar with the TN. But if you're a Canadian citizen or a Mexican citizen, you can avail yourself of a TN visa. The TN requires employer sponsorship, and it is a professional visa, and there is a list of professions that are eligible for a TN. But if you can find an employer in the United States who's willing to sponsor you. Obtaining a TN is pretty straightforward. Additionally, a TN is not limited in years. There are people that I helped obtain TNs 25 years ago that are still in the United States, still working on TN visas. L1 intracompany transfer. If you are working for an international company and they want to transfer you to the United States, they can do so if you've been working for that company for at least 1 year and you are in a management or a specialty position within that company, and they would need you here in the United States. The H1B1 for people from Chile and Singapore, the E3 from Australia. Again, all of these require employer sponsorship. Those are similar to the TN visa that's available to people from Canada and Mexico, which would allow you to work if your profession falls within the parameters of those treaties. O1 extraordinary ability is available to everybody from any country. It is similar to an EB1A, meaning it requires extraordinary ability. There are 10 criteria which would allow you to establish extraordinary ability. You must meet 3 of those 10 criteria. For a postdoc or researcher, the most common criteria that are met are that you have published in scholarly articles in peer-reviewed journals, that you yourself have done peer review and judged the work of others, and finally, that you have original research of major significance in your field. Those are the 3 most common criteria that postdocs and researchers attempt to establish as meeting 3 of 10 criteria. If you can meet 3 of those 10 criteria, you can qualify for an O1 visa because there is no final merits determination. That's what sets the O1 apart from the extraordinary ability EB1A, other than the fact that one's non-immigrant and one's an immigrant visa. The O1 does not lead to permanent residence. However, an EB1A allows you to either do consular processing or allows you to adjust status and obtain a green card. The first O1 is good for 3 years, but it must be renewed annually after that. However, there is no limit to the number of renewals. And the O1 is an excellent choice for postdocs who want to go into industry but are unable to obtain an H1B. There is no limit as to when you can get an O1. There are no limit on the number of O1s. And so if you can find an employer in industry who wants to hire you and you're well qualified, they can apply for and obtain an O1 on your behalf. And so you do not have to go on an H1B to go to industry. You are subject to the 2-year home residency requirement. If you are subject to it, the O1's a great choice. So if you're on a J1 subject to the 2-year home residency requirement, you can go on an O1 because you do not need a waiver of the J1 2-year requirement to obtain an O1 visa. You do, however, need a waiver of the 2-year requirement if you're going to go on an H1B because of the H1B's dual intent. And so we have a lot of clients who've been offered jobs at various universities that we represent, who are on a J1 subject to the 2-year home residency requirement. Therefore, we can't get an academic H1B. And so we apply for and get O1 visas. Another reason to go on to an O1 is if you're subject to long priority date wait times. So if you are subject to long wait times, you can't get an H-1B because J-1's limited to 5 years. F-1, you still have to be in a qualifying study program. The O1 can allow you to stay in the United States for an extended period of time. So this is something that you should keep in mind. Is the O1, if you're talking to employers that want to hire you, don't be afraid to bring up the O1. The individual can pay for the O1 visa and the application. And so a lot of times clients, employers, when they talk to us about the O1, are willing to do that. So don't not consider it, because it's a very valuable visa, especially for people like yourselves who are postdoc researchers that are highly qualified. So most of you are probably going to want to stay in the country long term. And to do that, you have to typically obtain permanent residence. You can stay in the country long term on an O1. You can stay here long term on a TN. But we often get people who are on TNs and O1s who want to get permanent residency because they feel there's always a little uncertainty if they should lose their job, that they would be able to remain in the United States. And so obtaining permanent residency gives that security to you. To obtain a green card, it is a two-part process. First, you have to establish that you are qualified under one of the permanent residence visa categories. So to get permanent residence, you have to establish you're qualified. For example, on a family-based case, you have to establish that you have married and are in a legitimate relationship with a U.S. citizen. You would file that initial application. Once it was approved, you can move forward with the second part, which is to establish that you're qualified for permanent residence. This is where you either go through the I-45 process or you go through consular processing, and they do a background check. And so two-part process. One, do you qualify under the visa category? And two, do you qualify for permanent residence? So there's two parts to the process. So the main categories for permanent residence is there's the employment-based permanent residence, where it is sponsored. It's the labor certification process. It's done through testing the U.S. job market. So the employer would advertise the position as vacant. And then they would, once they get through that, they would file the petition on your behalf and obtain permission, get the I-140 approved, obtain permission for you to file the I-45 adjustment of status. EB-1B, that's the outstanding professor researcher position. So that requires employer sponsorship. It is an extraordinary ability petition, and it requires the university or the research institute to sponsor you. If you are in a faculty position, you are required to be either in a tenure or tenure track position to qualify for an EB-1B. If you're a researcher, you need to be in what is deemed to be a permanent position. So a permanent position is one, very simply, where it is a matter of whether you have an expectation of continued employment. It's not as complicated as it sounds. USCIS recognizes that most researcher positions are subject to funding, that they're on one-year contracts, but those are still considered permanent positions should you have an expectation of continued employment. And finally, there's the self-sponsored petitions. This is the bulk of the work that I do. I work with individuals working on self-sponsored employment green cards. So to self-sponsor, there's no labor certification. You don't require an employer to sponsor you. You can file on your own. So the most common self-sponsored petition is the national interest waiver. I'd say the national interest waiver makes up probably 70 to 80% of the work that I do. The other extraordinary ability, EB-1A, the EB-1A is becoming more popular these days because of priority dates. So we'll talk about that. And finally, there's the EB-5 investment visa. If you have well over $1 million, you can invest it in the United States, and after a series of complicated process, you can end up with the green card. So today we'll just talk about the first two. So the national interest waiver is based on your proposed endeavor. What is it you're going to be doing? And the qualifications for national interest waiver, there's a three-pronged test. So the first test is whether or not your proposed endeavor is of substantial merit and national importance. To be of national importance, it has to have a broader impact. They have found and held in their decisions that teaching is not of national importance because it doesn't have a broad enough impact. It's limited to the students in your class, and therefore is not of national importance. Research that you may be doing and publishing oftentimes has national importance because the work that you're doing is shared with others, utilized by others, and therefore has a broader impact. If the work you're doing only benefits your employer and doesn't extend beyond the four walls of your work, it will not be of national importance. And so the proposed endeavor, national importance, is forward-looking. It's about what you're going to be doing. Is what you're going to be doing of substantial merit and national importance? A lot of people make the mistake of arguing what they have done as having had national importance and having had an impact. That is not the first prong. The first prong is forward-looking. What is it you're going to be doing, and how is what you're going to be doing going to be impactful and of national importance? The second prong looks at past success. This is where you establish that you are well positioned to advance your proposed endeavor. You show this through your education, your experience, and success. You show success by showing how people have utilized your work in some manner. So if you're a researcher, you're publishing, you can show success through citations. If you have a patent, you can show how it's being commercially utilized. If you don't publish, you don't have patents, let's say that you're doing work that results largely in reports. You can show success by showing how those reports are being utilized by others. Several years ago, I would get people who would come to me who were doing testing for pharmaceutical companies. They weren't publishing, they weren't doing anything, they were just working to help get products FDA approved. And so we would show how the work that they did was leading to the approval of pharmaceuticals by the FDA. No publications, no citations. and able to get those cases approved by showing that they were well qualified through their education experience to do the work that they were doing, and that they'd had success in that field through the history of their work, and that their work was of national importance because their work was leading to the development and approval of new pharmaceuticals, which obviously impact public health. And so that is how you would look to make a national interest argument. The third prong is, on balance, it would benefit the United States, being the national interest, to waive the labor certification, thus the name, national interest waiver. What they're waiving is labor certification or the requirement that you have a job offer and be sponsored by an employer. This basically says that it would benefit the US to have you here, even if there were other workers who could do what you do, because what you do and what you offer to the United States is of national interest. The third prong typically falls into place if the first two prongs are established. I have never seen a case denied on the third prong only. Letters of support. There's a lot of debate going on right now whether letters of support are necessary for a national interest waiver or not. We highly recommend that you take the time to get letters of support to help you with your national interest waiver. The reason is USC policy guidelines recommend that you get letters of support. These letters of support corroborate the claims that you make. You're going to be claiming that you're working on projects that are of national importance and that you're going to be working on these projects. How do you corroborate that without getting a letter from your PI or your PhD advisor as to what it is you're working on or what it is you're going to be working on? And so at a minimum, you should have at least one letter of support. Having additional letters can be very beneficial. If you have letters of support, you're going to have less chance of getting a request for evidence. Getting a request for evidence is going to significantly delay the approval of your case. And so taking the time up front to get letters of support is worth it. And the most important reason to me why you should have letters of support is because if your case for some reason is denied, and strangely enough, some of the cases that we get denied should never, ever have been denied. And on those cases, I have appealed them, and I have won those appeals. And I've won those appeals on the strength of the letters of support that were presented with the case. If you read the administrative appeals opinions, the cases that are won on appeal typically turn on letters of support that were provided in the petition. As a former trial lawyer, establishing the record through evidence by providing evidence up front so that you can appeal your case if you have to. Again, it's very rare that you have to appeal a case, but if you do, it's very helpful to have those letters of support. With the NIW, there was an update to the USCIS policy guidelines, how officers should adjudicate an NIW case. If you have an advanced STEM degree, a master's or better, in a STEM field, it is looked upon as being strong evidence of your being well positioned to advance your endeavor. If you are working in an area that's considered to be a critical and emerging technology, that's very helpful in establishing that your proposed endeavor is of national interest, or excuse me, national importance. And so if you're working in a STEM area, after these adjudication guidelines came out, it increased the chances of success for people who have an advanced STEM degree. You can file an NIW from anywhere in the world. You do not need to have underlying status. Several of the questions that were provided to me talk about, can you do this from your home country? Absolutely, you can. I have clients that I've obtained green cards for that had never been to the United States prior to getting their case approved, going through consular processing, and entering the United States as permanent residents. You do not have to be in the United States. You do not have to have underlying status. Because of this, you can file for a national interest waiver even if you're a PH student on an F1. You can apply if you're on a J1. A lot of people believe you have to move to a dual intent visa like an H-1B to apply for the national interest waiver. That is not the case. Additionally, even if you're subject to the 2-year home residency requirement, you can still apply for the national interest waiver. You can apply for an EB-1 extraordinary ability should you choose. The 2-year home residency requirement does not affect your ability to apply for the underlying immigration petition. What it does prevent you from doing, if your case is approved, you cannot adjust status to a green card, or you cannot go through consular processing until the 2-year requirement is waived or you've fulfilled it. We have a website, nationalinterestwaivers.com. On that, we provide a lot of additional information about national interest waivers. Additionally, I have a blog on there where I talk about updates on things that are happening related to the NIWs. For example, when the STEM initiative came out, I wrote a blog discussing that, how it would impact things. Also, on those blogs, I link to the source material. So if you see critical and emerging technologies, you're wondering what that is, you would just click on it and it would take you straight to the critical and emerging technologies list. So if you want to review some of those things, you're welcome to. Additionally, on our site, we have an area called notable approvals. It's a long list of cases that have been approved. And on there, we just quickly summarize the areas of study, what their position is, whether it's a PhD student, a postdoc, a person working in industry, and just give a brief explanation of what it is they're doing and whether they have publications and citations, if so, how many. And so it can give you just sort of a guideline of whether or not you should be even thinking about it. NIW premium processing is available, became available at the beginning of this year. The fee is $2,500 and you get a decision guaranteed within 45 days. Typically, the decisions are taking anywhere from 5 to 10 days. NIW premium processing is going very quickly. However, non-premium processing cases are taking anywhere from 3 to 6 months. Premium processing is not worth $2,500, except for a few exceptions. The reason it's not worth $2,500 is because of priority dates. I'll talk about those in a minute. But even if you get your case approved quickly, you're still going to have to wait for a green card to become available. And that's likely to take far longer than the 3 to 6 months that it would take to get approval without paying the $2,500. So the extraordinary ability green card, like I said, more and more people are wanting to file EB-1As. Similar to the O1, you must meet 3 of 10 criteria. However, the difficulty that arises for the EB-1A, in particular for postdocs, is there's a final merit determination. In that final merit determination, you have to establish that you are one of the small percentage who have risen to the very top of your field of endeavor. It's not, you don't show that you're a top postdoc. You have to show that you're one of the top in your field. So if your field is organic chemistry, you need to show you're one of the top in the field of organic chemistry. They'll compare you to your PI. They'll compare you to the people who write letters of support for you. It is faulty analysis that many officers do, but getting an EB1A is particularly difficult because of the final merits determination. And because the final merits determination is subjective, there is an element of luck as to which officer you get. There are officers that are notoriously difficult, and when you see their number on the request for evidence, you know that the chance of it getting approved are extremely low. There were important clarifications made as to how an officer is to adjudicate an EB1 and how to adjudicate each of the 10 criteria. And those were put into existence only a matter of days ago. It was beginning of, I want to say, last week. Days go quickly for me, so it was in the month of September that the new EB1A guidelines were issued. And so it remains to be seen, but I think based on those guidelines, if you are a researcher, the chances of getting an EB1A should increase and should improve. At least that's what I'm hoping. And again, it remains to be seen. So the question we often get, am I qualified? If you would like to know whether you're qualified, the easiest way to find out is to contact Kayla, and you can schedule a free, no obligation consultation. So as a way of saying thank you for your time and the opportunity to speak, I'm willing to give additional time back to you one-on-one to talk about your qualifications. Even if you're not qualified, and I can give you some guidance on how you may become qualified. If you would like to have one of the consultations, again, a lot of people, international students, are afraid to talk to a lawyer because they're afraid it's going to cost them something. This is absolutely free, no obligation, and I'm happy to speak with you. If you would like a consultation, let Kayla know that you're requesting the consultation as part of the Ohio State presentation. That way I'll know to get it set up. I'm happy to do it. So if you would like to speak with me, please let Kayla know. So the last part is the I-485 application to adjust status, and if you're in the United States, or consular processing. This is the point at which you would add your family members. USCIS allots a limited number of green cards for each employment-based category. And these allotments are based on your nationality at birth. So it's your nationality at birth. If you, for example, I get a lot of clients who were born in India but have become Canadian citizens, and they want to know if they can use Canada for their priority dates. Unfortunately, you cannot. You have to use your country of birth. And I use India as an example because the priority dates for India for employment-based petitions are extended. It can take many years to get a green card through an employment-based petition if you're from India. Green card applications are subject to priority dates. The priority date is set when you file your initial case with USCIS. It's not the date of approval, but the date of filing. It identifies when a green card will be available to you. When your priority date becomes current, you're eligible to file an adjustment of status if you're in the United States. These are the dates for filing numbers that are on the dates for filing chart. If you're doing processing outside the United States, a green card will be available to you based on the final action dates. The Department of State Visa Bulletin is updated each month and lets people know what the priority dates are going to be for the previous month, for the upcoming month. And so the priority dates are important in determining when a green card will be available to you. So priority dates are going to improve in a couple of days when October gets here. For EB1, all countries except for India and China will again be current. They had retrogressed, meaning if you have an EB1A petition that has been filed or approved, you don't need to have an approval to file an I-45. If you have a pending EB1A, I-140, you can file for adjustment of status. If you're from China, you're going to have to wait. If you're from China, you're going to have to wait a couple of years, year and a half, 2 years. If you're from India, you're going to have to wait approximately 4 years now under the EB1A. Under EB2, cases filed in 2022 will be current for all countries except India and China. India, you're going to have to wait approximately 11 years under the EB2. For China, it's approximately 4 years. Because of the retrogress priority dates and it's taking longer now this year than it ever has in the past 4 or 5 years. This is the first time, this year's the first time that EB1 and EB2, well, EB2 in particular, was not current for an extended period, and it doesn't look like it's going to become current again anytime soon. So it's more important now to get an EB2 priority date. And the earlier you apply, the earlier you're going to get your priority date. For people that are wanting an EB1 and especially India and China, I recommend getting an EB2 now. Get a priority date now, because you can add the EB1 later. The longer because if you wait until you believe you're qualified for an EB1 and you file for an EB1, you're still going to have an extended wait time for your priority date to become current. If you apply now, get a priority date, and let's say 3 or 4 years from now, you qualify for an EB1, you file that EB1, and you can use the priority date from your EB2. Very important. If you want to be here long-term, you're from India or China, you should file the EB2 and worry about, unless you're absolutely qualified now, worry about the EB1 later. Another reason to file an EB2 is that an EB2 approval, I-140 approval, allows an H4 dependent to get a work authorization. The only way an H4 dependent can work is through an approved I-140. So, all right, I will get to the questions that were initially submitted. I've got several in chat, and then I will stay as long as necessary to answer whatever questions you have. I will go ahead and turn off the recording now.
Recording stopped.
And I will provide a link to the recording that the Postdoc Association can share with you. So, the question is, can I go back home for work and wait for the green card, come back home when it's ready? The answer to that very simply is yes, you can. As I mentioned, it's not required that you I'm just trying to adjust the screen so I can see everything here. It's not required that you be here, so you can do this from anywhere. I'm on an H-1B, husband on an H-4. I'm considering EB-1, EB-2, so that the spouse can get an H-4 ED. What is the cost for applying for an EB-1 or EB-2 NIW? I can only speak for our firm. We charge the same for an EB-1 as we do for an EB-2. Our attorney's fee is $3,900. We have multiple payment options. You can pay over time. But that $3,900 is good for an EB-1 or an EB-2. If you do an EB-2 with us and then want to do an EB-1 later, then we do it for a reduced cost. We do it for $1,900. And that's why I do an EB-2, do an EB-1 a couple years later, and I've done this for a lot of clients. We do it at a substantially reduced cost because you may not qualify yet, and you may want one going forward. So the cost is the same. But if the goal is to get an H-4 EAD, apply under the NIW because it's a lower standard and it's easier to obtain. So getting the NIW, and that's about the only reason I recommend premium processing on the NIW. That $2,500 becomes an investment in getting that H-4 EAD several months sooner. So 3 months of work probably more than covers that additional $2,500 premium processing fee. How long does it take to get an EB-1 or EB-2 approved? It doesn't matter what country you're from. Like I said, the not premium, it's going to matter of days, non-premium, 3 to 6 months. If the J1 visa DS 2019 are valid, also EB-2 is under consideration. What is your recommendation considering the priority date is retrogressed? Will I have any issue traveling to India on a J1 visa returning to the US? You shouldn't have any problem. Although you have an approved I-140, because of the priority dates having retrogressed so much, it's really difficult for you to have immigrant intent. I have had clients who have gone back to India, renewed their F1 visa, and come back to the US with an I-140 pending just recently. It's not something that we recommend, but if you are from India, you have an I-140 approved, you have an I-140 pending, there shouldn't be a problem because the priority dates have retrogressed so much. I would make the same argument for China with respect to at least the EB-2. However, if you're from any of the other countries, again, we suggest you exercise caution if you travel with an I-140. And fortunately, it is not black and white. It is an incredibly gray area because all USCIS officers have discretion as to whether they're going to let you into the country, regardless of whether you have a visa or not, and regardless of whether you've even filed an I-140. And so exercise caution, but I would say that if you're from India, the chances of having a problem are extremely low. What are the possibilities of getting a green card for a postdoc scholar with 20 articles, 200 plus citations? You would have a very good chance of getting a green card with those types of qualifications. In fact, yeah, so if you wanted to discuss what your options were and what your best pathway is, depending on where you're from, depending on some of that work in your field. The question where you are with 200 plus citations is whether an EB1A or an EB2 NIW would be your better pathway. Again, that's going to depend on your underlying status, what your long-term plans are. So that's where a consultation can be helpful for you to come up with a long-term plan that's best suited for you. Does a speeding ticket significantly make it harder to get a green card? No, speeding tickets, unless you have a propensity for speeding and you have hundreds of them, getting a traffic ticket is not going to impact your ability to get a green card. Getting them and not paying them, that's a different story. I'm single. If I get my I-40 approved, do I file I-140 for my future wife before applying for I-45? No. You only need one approved I-140. When you're able to apply for an I-45, that is when you add your family members, your spouse and children if you have them. So I-140 for the one individual. Time to get the green card, I-45, you include your family members, same as if you're doing consular processing outside the US. I have clients that are in the US, have family members outside the US. They apply for an I-45 in the country and do consular processing for their family members outside the US. How long is the whole process for getting the green card? That depends on the category, whether it's a family-based or an employment-based, whether it's extraordinary ability, exceptional ability, employment-sponsored. So, and it depends on what country you're from. So let's just base it on the employment-based, which are the most common. The NIW, if you're not from India and China, is probably going to take you approximately 18 months to 2 years. If you're from China, under the NIW, it's likely to take 4 years. India, 11 years. Under EB1, if you're from India, likely going to take probably 5 to 7 years right now. China, about 2 years. If you're from any other country, it can take anywhere from 6 to 18 months. Does a green card include work permission? A green card does include, a green card allows you to live here, work here, travel, etc. The green card application, which would be the I-45 application, you do apply for work permission when you apply for the green card. That is the EAD card that is applied for when you file the I-45. You can only get it through filing an I-45. You cannot get work permission through doing consular processing. That, the only thing you get through consular processing is approved for permanent residence. Is there permanent premium processing to expedite the green card? There is not. There's premium processing for the underlying applications, but there is no premium processing to make the green card process go faster. Can I travel outside the US during the green card process? It depends on what stage you're at. If it's the initial application, although we recommend you not travel, again, there's not a bar. However, once you file the I-45, unless you have a dual intent visa like an H-1B, you cannot travel. It's black and white once you file an I-45 adjustment of status that you cannot travel. So you have to wait to get what's called advanced parole to travel after you filed for an adjustment of status. So unless you have a dual intent visa, you cannot travel during the second part of the process. Can you change J1 as postdoc to H1B? You can change from a J1 to an H1B if you are not subject to the two-year home residency requirement. I'm a J1 visa holder. My husband is a green card holder. Should you file a follow to join or an I-130? Depends on where you are, whether you're inside the United States, outside the United States. If you're inside the United States, you're married to a green card, and I guess it depends on how long your husband's had the green card. So too many variables for me to answer that question. But if you're in the United States, you're married, your husband has a green card, you can file an I-130. I'm working as a postdoc with J1. My visa will end in November, but obviously the DS 2019 appears to be good until January. Am I allowed to be here after the visa expires? Yes. You do not need a valid J1 visa. What you need to have is a DS 2019 that is still valid and current. So I have many clients that have expired J1 visas and have had multiple DS 2019s extending their authorization under the J1 to continue working in their program. So if you extend your appointment for another year, you're allowed to stay here past the expiration of your visa. My current J1 is ending in June 2024, is not subject to 212. If I land an academic position, what documents do I need to have in order to apply for a J1 or be converted to, for a J1 to be converted to an EB1? I think you're wanting to say H1B. EB1 is a self-sponsored extraordinary ability. So the EB1 is not something that you convert from a J1. You would have to get an EB1 approved and then do adjustment of status. Based on what I'm seeing here, that would be difficult to do by June 2024. But I think what you're wanting to do is convert from a J1 to an H1B. There's nothing really, if you've got a J1 that's not subject to the 2-year rule, the university will file the H1B on your behalf. There's nothing really that you need to do. If you're subject to the 2-year residency requirement, you will need to get the waiver before the university can do the H1B. Is filing with an international address better under an EB1AI 140, even though current workplace is Ohio State? There is no benefit to applying from outside the country because I've heard people talk about this. They're trying to game the system to try to get it in a different, to get it out of the Nebraska Service Center. And the fact is your EB1A is, and where it is processed is based upon your place of employment. So in order to game the system, to try to get it out of Nebraska by using your home country, I don't know how you would do that if you're being honest about where you're working and who you're working for, because that is what it is based on. So do I recommend doing it? Absolutely not. I get this all the time. Apparently there are some firms out there that are trying to game the system and recommend doing that. I don't recommend it at all, because it could come back to haunt you, because if they're trying to do that, there may be some misrepresentations being made. I don't know. I'm not saying anything. I don't know. But to me, when people talk to me about that, it's very troubling, because it's very clear that the case will be processed in the jurisdiction in which your employment is based. If time permits, well, I'm happy to do it. My I-140 has been approved. My F1 visa expires. My home country is China. I'm waiting to see if I can still get my visa issued in my home country and then come back for the U.S. for PA study if I need to stay in the U.S. until, again, same thing. Are you trapped here? If you're from China, can you travel back? I mean, your F1 visa is expired. As long as you have a valid I-20, you can stay in the U.S. until your priority date comes current and file for your green card. If you're wanting to travel back to China to visit your family, do those things, get a new F1 visa. There's nothing prohibiting you or preventing you from doing it. It's just there is a risk that they may not renew your F1. If they do not renew your F1, then you would need a different status to enter the US because you need a valid visa to enter the US. So it's up to you to determine what type of risk you're willing or wanting to take related to going home and then coming back. But you don't need a valid F1 visa to stay here. You just need to keep, like with the J1, you don't need a valid J1 visa. You just need a valid DS 2019. For students, you need a valid I-20. All right. Please suggest the best plan for a grad student who started their semester recently. Best plan, submit your documentation to Kayla and I'll talk to you and we'll come up with a plan. All right, let me get to the chat here real quick. There's several questions there. All right. I was in the US previously as a visiting scholar on a J1 short term. I came back as a postdoc, transitioned to a J1 research without waiting 2 years. My first visa, I was subject to the 2-year rule because of government funding. I was subject to the 2-year home residency rule because of the skills list. In this case, do I need to apply for 2 separate waivers? Unfortunately, yes, you'll need a waiver for the 2-year rule based for government funding and then a 2-year one based on the no objection letter. What is the best strategy for a J1 postdoc to get permanent residence? Again, contact Kayla. I'll talk to you. I'll look at everything and I'll give you a plan. Like I said, no obligation. I'm currently on a J1 visa. If I start the NIW process, can I extend my J1 if my green card is not completed? Yeah, so doing the NIW process does not affect your ability to extend your J1. You can extend your DS 2019 if you start the NIW process and you're waiting for your priority date. If you are subject to the waiver and you apply for a 2-year home residency waiver, then that affects your ability to extend your J1. And then you'd have to get a new J1 and you'd be subject to a new 2-year residency requirement. How much does it cost to apply for an NIW EB2, including all fees and everything? So the total cost on our end for everything doesn't cost a penny more. It's $4,700, and that's the total cost for everything. What that includes is the attorney's fees, which are $3,900, the $700 USCIS filing fees, And then there's $100 out-of-pocket expense fee. That's a flat fee that covers overnight Federal Express shipping, which is, it covers all extraneous costs. It includes responses to RFEs, all mailing of approvals and notices. And so that is a total flat fee cost for everything for an EB2 NIW, for an EB1A, for an O1. It's a flat fee for the first part of the process. If you want to do the adjustment of status or consular processing, there are additional filing fees and attorney's fees for that. And that depends on how many people are in your family, where you're going to be filing and all those things. And so that is variable. But for the first part, $4,700, that's it. Will publications from my time when I was not affiliated with a U.S. institution be considered in my NIW application? Yeah, absolutely. I have clients that, like I said, have never been affiliated with a U.S. institution. Clients that are from all over the world. I have many clients in the U.S. that are just starting their postdoc here, and we rely on the work they did as a PhD student in a foreign country. So you do not need publications from your current U.S. institution. In fact, you don't even need publications if you can establish how your work is utilized. If I apply for my I-140 and get approved, will my university still renew my DS 2019 before? Can my university apply for an O1 visa for me as a postdoc? So, yeah, if your I-140 is approved, they can extend your DS 2019. It's done all the time. Again, where the problem becomes is if you file the I-45 adjustment of status, that's when things get difficult to extend or to apply for a new visa. But can you get an O1 visa as a postdoc? Absolutely. They can apply for an O1, and you can change status from J1 to O1. And you can do that even if you're subject to the 2-year home residency requirement. And you can apply for the I-140 if you're subject to the 2 years, and they can still extend your DS 2019. So applying for the I-140 itself is not very restrictive. The main restrictions come in when you apply for the I-45. Can I travel to US when waiting for a green card? That infers that you're outside the US. Yeah, if you have a valid travel visa and you're doing consular processing, you absolutely can travel to the US. You just have to be able to, if questioned, let the officer know that you'll be returning home after that trip so that you can complete the green card processing. This is my last year for J1. My application to transfer H1B is in progress. When do you suggest me starting the green card process? Sooner the better. You do not need to wait to go from J1 to H1B. You can start the process as an F1 student. You can start the process as a J1 exchange visa. You don't need an H1B. You can start the process at any time, and you can always transfer to an H1B at any time during the process. So because of priority dates, the sooner you start, the better. You do not have to wait to go from J1 to H1B. Filing an NIW petition will not have any impact on either of the processes. Mentioned that having letters of support is important, but how many do you think are recommended? We typically recommend having approximately 3 or 4 letters. We find those to be sufficient. Obviously, like I said, the PI or PhD advisor, and if they're different people, both of those can be very helpful and very important letters. And then if you want to go beyond that, having an independent letter from someone who's familiar with your work, seen you at a conference presenting, cited your work, or relied on your work in some way, those types of letters can be very helpful as well. There is not a maximum, but the law of diminishing returns, there's only so much people can say before they start repeating themselves, and you don't want that because USCIS frowns upon letters that are repetitious, because then they begin to think that there was collaboration done in writing the letters beyond the norm. How many citations are enough? Again, you don't need citations. Citations are just one factor of showing success in the field. But if all you have are publications and citations, typically, if you have over 10 citations, your chances of success go up considerably. Less than 10, you can still get approved. Again, depends on your field, depends on what you're doing, depends on what you're working on, depends on what you've done. You can still get them approved. I've had them approved with as little as 1 citation. So citations, there is no magic number. General rule of thumb, 10 or more. Postdoc on OPT, originally from Italy. Been on an F1. I attended, okay, lots. They asked you when you were going to finish and gave me only a 1 year. Right now, my F1 is expired. I'm concerned about going back to Italy and ask for an F1 one more time. Yeah, I would be concerned too. You can continue to get an I-20, stay here, but returning and seeking another F1 could be problematic. If you're a postdoc on OPT, you should be able to explain to them that you have finished your education and that you're simply completing your optional practical training, of which you have, if you're STEM, a total of 3 years. And so they should be willing to extend your F1, knowing that you've completed your education and you're on the allowable and mandated optional practical training with STEM extension. So should you have a problem, you shouldn't. But with anything dealing with consular officers, you never know what they're going to do. So I would be a little bit reluctant if that was the case. But should it be a problem? It shouldn't. One thing you might want to see if you're on a postdoc is being able to transfer over to a J1 or going to a H1B, and that can solve that problem. Do we hope the EB1 priority date for India is going to improve in the next year? We do hope the EB1 will improve. We also hope the EB2 will improve. Both of them had improved significantly in 2022. But at the end of 2022, everything took a huge jump back. The EB1 just took a huge jump back at the beginning of last month. We thought it was a typographical error when it dropped back 10 years. But then it moved forward again. It's moving forward again in October by 6 years. So I am optimistic the EB1 in particular will improve, but I also believe the EB2 will improve for India this year as well. Does sequence of authorship on a article impact? No, they really don't pay attention. In the NIW, they don't really pay attention to whether you're first author, second author, corresponding author of some type. They don't pay a lot. EB1, they do look a little bit more at whether or not you're a first author or the last author, indicating that you were the one that was responsible ultimately for the publication and the project. All of that, of course, has to be explained to the officers, but in an EB1 carries more weight. NIW doesn't carry much weight at all. Is it recommended to travel outside the U.S. after obtaining the J1 waiver? The J1 waiver has no effect on the J1 itself. If you have a valid J1 visa, you can travel outside the U.S. and come back on your J1 visa. All the waiver does is say that you don't have to fulfill your 2-year home residency requirement. And so getting the J1 waiver does not affect your J1 visa. It affects your ability to extend it, but it doesn't affect your ability to use the visa to travel. Is the I-140 filed first or I-45? The I-140 comes first. The I-45 comes second. Same as in the way they process the cases. In an EB1A, you can theoretically file them both together, but the I-140 is always processed first, and we don't recommend filing an I-140 and I-45 concurrently on an EB1 because the chance of an EB1 being denied is high. And it's a waste of money because the I-45 would automatically be rejected and the filing fees on the I-45 are high. Once the I-140 is approved, can I work legally while the I-45 is filed or being processed? I-140 approval does not give you work authorization. Once the I-45 is filed, you're able to remain in the U.S., but you're not able to work until they issue you an employment authorization document. I know TN is a non-immigrant, but I know that some people have gone from TN to green card. Is this route common, recommended? I've helped many people go from TN to green card. Or would you recommend sticking with F1, H1 green card if I'm currently on an F1? Yeah, if you can go F1, H1B to a green card, that's going to be a more secure way to go. TN being non-immigrant can have some risk to it, not a lot. Again, the possible limitation to travel. So if you can go F1, H1B to green card, probably your best option. How much does it usually take to get approved on I-140 with Iranian nationality? If you mean how long does it take? I-140 approval, I-140 decisions have nothing to do with your underlying nationality. I-140 decisions come at pretty much the same pace for everybody from all countries. The cost for the I-140 for us is the same regardless of nationality. Paying premium processing for the I-140 will not help expedite the I-45. It has no effect on the I-45. It's of no benefit to the I-45. Doing the premium processing for the I-140 will not get you a green card faster. You're still going to have to wait on priority dates. You're still going to have to wait on I-45 processing. There is no expedite for the I-45. You're from Iran, you're on a J1, you're considering a trip to another country after filing the I-140. Will you face problems coming back to the US? I personally wouldn't do it. I personally wouldn't do it. I would cancel the trip. So I'm an Indian citizen with proved Canadian permanent residence. As far as the immigration process to the United States, you're subject to India priority dates. Even if you become a Canadian citizen, because you're an Indian national by birth, you're always going to be subject to India's priority dates. Unless you marry someone from another country. There is that if you do marry someone who's not a US citizen and you can't do family-based, if you're from India or China and you marry someone from another country that's not subject to the same priority dates, there's what's called cross-chargeability, and you can use the priority date of your spouse to adjust status. I'm just finished my master's, first year PhD. Should I wait? Yeah. If you're an early PhD student without significant publications and citations, and all you have really are poster presentations, you're going to want to wait until you have some peer-reviewed journal articles published and some citations under your belt, or some way to establish that your work has been utilized in some manner. So I would wait a little bit if you're a first-year PhD student. Last question. Not sure what the question is. Okay, does traveling outside the US after J1 waiver cause 212E to reattach to your J1? No, it doesn't. Travel does not have the 212E reattach. Once you have the waiver, you have the waiver. What would reattach to 212E would be getting a new J1 visa after you have already gotten your waiver, or getting a new DS 2019 issued after you already have your waiver. So, all right. Well, thanks everybody. Oh, is the free consultation face-to-face or an email-to-email conversation? It's typically a telephone conversation. But if you want to do a Zoom face-to-face, we can do that if you request it. But typically I do my consultations over the phone. So they're not email. You're talking to me personally, but typically over the telephone. So, all right.
Thank you so much, Jim, for such an informative session, and also for always staying back and answering all the questions and the free consultation that you offer. I'm so sure so many postdocs will be, appreciative of that. And I want to thank all of the postdocs on the call for attending this session. We'll share the recording as soon as Jim shares that with us.
And I should have that to you sometime tomorrow.
Okay, awesome. That sounds great. Have a good evening, everyone.
Yeah, have a wonderful evening. Good night.
Bye.